Good morning, classmates. Good morning, sir. Today I am the reporter and I will be presenting to you through this vlog reporting. But beforehand, I would like to introduce myself first. I am Lionel A. Barrientos, a civil engineer by profession. As we continue, I will be presenting to you this morning the topic regarding laws and regulations concerning groundwater. So that would be my topic for today. But beforehand, before we go to the laws and regulations concerning groundwater here in our country, let's have a review first and a quick view of what is groundwater.
Did you know there's a vast source of water beneath us that we can't see? It's called groundwater, and it's found within rocks and sediments below the ground surface, filling the gaps between grains of sand and fractures in rocks. Unlike the rivers and creeks we can see, groundwater moves very slowly and can take a long time to react to changes in weather patterns. Groundwater can be there to use even when it hasn't rained in a long time. Groundwater is an important source of water for towns, industry, farming, and the environment. It's especially valuable during drought, when rivers and creeks dry up. That's why it's important it's managed carefully, so it can be used now and into the future. Groundwater can be accessed using a bore. The amount of water that can be pulled out of each bore depends on the type and arrangement of the rocks beneath the ground. But when there are several bores in a single area, the water level over a larger area can decline. When too much groundwater is taken or the source becomes contaminated, it can have long-term or even permanent impacts on the communities and ecosystems that depend on it. In New South Wales, groundwater is managed by water sharing plans. These plans manage and monitor all water used by irrigators, the environment, industry, towns and communities to make sure everyone can use groundwater fairly and communities and the environment stay healthy. Whether it's up here or down there, the way we manage water matters. To find out more about how groundwater is managed in New South Wales, visit our website.
What are the things or the agents that can affect groundwater that it can be contaminated? Since what could be the reason why we protect groundwater? So, kailangan pang gumawa ng mga law and regulations to protect groundwater. So, what are those contaminants? So, as you can see, these are the contaminants that can affect storage tanks, septic tanks, uncontrolled hazardous waste, landfills, chemicals and road salts, and atmospheric contaminants. So among those are the common agents that can make our groundwater contaminated. Okay, so why do we need, again, the question will be raised, why do we need to protect our groundwater? Is it essential to protect our groundwater? Okay, the reason why we need to protect our groundwater because drinking contaminated groundwater can have serious health effects. Diseases such as hepatitis and dysentery may be caused by contamination from septic tank waste. Poisoning may be caused by toxins that have leached into well water supplies. Wildlife can also be harmed by contaminated groundwater. Other long-term effects, such as certain types of cancer, may also result from exposure to polluted water. So it is very important that we must protect our groundwater. So in our country and different countries, different states, different nations have different laws on how to protect the groundwater. And then here in the Philippines, we have lots of laws also and regulations concerning groundwater. Some I will be presenting it to you this morning. What are the laws protecting groundwater? What are those laws? These four major laws that has been passed by the Senate, the Republic Act of our country. These are the four major laws that we're going to tackle or to discuss this morning. We have RA 9275, RA 8749, RA 9003, and RA 6969. Since it is a Republic Act, it was being passed on the Senate, was being promulgated all throughout the country, and then until today, it is being effective and it is being practiced. First, let's discuss about Republic Act 9275. So, what is this law? RA 9275, an act providing for a comprehensive water quality management and for other purposes. It was being approved and signed by President Gloria Macapagal Arroyo on March 22, 2004. On the Article 1, Section 1 of this act shall be known as the Philippine Clean Water Act of 2004. On the Section 2 of this RA 9275, Declaration of Policy, the state shall pursue a policy of economic growth in a manner consistent with the protection, preservation, and revival of the quality of our fresh, brackish, and marine waters. Achieve this end, the framework for sustainable development shall be pursued. As such, it shall be the policy of the state. And Section 3 of this act, coverage of the act, this act shall apply to water quality management in all water bodies, provided that it shall primarily apply to the abatement and control of pollution from land-based sources, provided further that the water quality standards and regulations and the civil liability and penal provisions under this act shall be enforced irrespective of sources of pollution. So mostly industries and companies who will be handling water will be under in this act. If we're going to check the Article 2, this Republic Act 9275, under the definition of terms, we will find out the letter R, S, and T, the groundwater section. So therefore, the protection of the groundwater is under of this Republic Act number 9275. In the Article 2, Section 13 and 14, it is the water pollution permits and charges. We have for the wastewater charge permit and for the discharge permits. I remember one time I have a company that I've been working to, and that company has a batching plant. Now, that batching plant, we all know that in mixing concrete, potable water or a clean water is a good paste for mixing concrete. And for us to have a batching plant, we need to secure a discharge permit. Okay, the discharge permit shall require owners or operators of facilities that discharge regulated effluents pursuant to this act to secure permit to discharge. On the Chapter 5 of this Republic Act, we have the civil liability and penal provisions. Section 27, the prohibited acts. The following acts are hereby prohibited. A. Discharging, depositing, or causing to be deposited material of any kind directly or indirectly into the water bodies or along the margins of any surface water, where the same shall be liable to be washed into such surface water, either by tide action or by storm, floods, or otherwise, which could cause water pollution to impede natural flow in the water body. B. Discharging, injecting, or allowing to seep into the soil or subsoil any substance in any form that would pollute groundwater in the case of geothermal projects and subject to approval of the department regulated discharge for short-term activities. Example, testing, flushing, commissioning, venting, and deep reinjection of geothermal liquids may be allowed, provided that safety measures are adopted to prevent the contamination of the groundwater. C. Operating facilities that discharge regulated water pollutants without the valid required permits or after the permit was revoked for any violation of any condition therein. D. Disposal of potentially infectious medical waste into seawater by vessels unless the health or safety of individuals on board the vessel is threatened by a great and imminent peril. E. Unauthorized transport or dumping into sea waters of sewage, sludge, or solid waste as defined under Republic Act number 9003. F. Transport, dumping, or discharge of prohibited chemicals, substances, or pollutants listed under Republic Act number 6969. G. Operate facilities that discharge or allow to ship willfully or through gross negligence prohibited chemicals, substances, or pollutants listed under RA number 6969 into water bodies or wherein the same shall be liable to be washed into such surface, ground, coastal, and marine water. H. Undertaking activities or development and expansion of projects or operating wastewater sewerage facilities in violation of Presidential Decree number 1586 and its implementing rules and regulations. I. Discharging regulated water pollutants without the valid required discharge permit pursuant to this act or after the permit was revoked for any violation of condition therein. J. Non-compliance of the LGU with the Water Quality Framework and Management Area Action Plan. In such a case, sanctions shall be imposed on the local government officials concerned. K. Refusal to allow entry, inspection, and monitoring by the department in accordance with this act. L. Refusal to allow access by the department of relevant reports and records in accordance with this act. M. Refusal or failure to submit reports whenever required by the department in accordance with this act. N. Refusal or failure to designate pollution control officers whenever required by the department in accordance with this act. And O, lastly, directly using booster pumps in the distribution system or tampering with the water supply in such a way as to alter or impair the water quality. Now, those A to letter O are the prohibited acts under this law. So whoever trespass those acts shall have a fines and penalties, and it has been written in the section 28 of this law. Fines, damages, and penalties, unless otherwise provided herein. Any person who commits any of the prohibited acts provided in the immediately preceding section or violates any of the provision of this act or its implementing rules and regulations shall be fined by the Secretary upon the recommendation of the PAB in the amount of not less than 10,000 pesos nor more than 200,000 pesos for every day of violation. Take note, it is every day. The fines therein prescribed shall be increased by 10% every 2 years to compensate for inflation and to maintain the deterrent function of such fines, provided that the Secretary, upon recommendation of the PUB, may order the closure, suspension of development or construction, or cessation of operations, or where appropriate, disconnection of water supply until such time that proper environmental safeguards are put in place and or compliance with this act or its rules and regulations are undertaken. This paragraph shall be without prejudice to the issuance of an ex parte order for such closure, suspension of development or construction or cessation of operations during the pendency of the case. So in this section, it is being said that the penalty will be 10,000, not less than but not more than 200,000 per day once you prohibit this act. And then every 2 years, it has a 10% increase to compensate the inflation or else cessation. Your operation can be stopped or your water supply can be disconnected until such you can provide that you will have a permit or talagang i-comply nyo yung kailangan na mga permits. And then what if mag-fail? So failure to undertake clean-up operations willfully or through gross negligence shall be punished by imprisonment of not less than 2 years and not more than 4 years and a fine not less than 50,000 pesos and not more than 100,000 pesos per day for each day of violation. Such failure or refusal which results in serious injury or loss of life and or irreversible water contamination of surface, ground, coastal and marine water shall be punished with imprisonment of not less than 6 years and 1 day and not more than 12 years and a fine of 500,000 pesos per day for each day during with the omission and or contamination continues. In case of gross violation of this act, the pub shall issue a resolution recommending that the proper government agencies file criminal charges against the violators. Gross violation shall mean any of the following: deliberate discharge of toxic pollutants identified pursuant to Republic Act number 6969 in toxic amount. The Republic Act 6969 will be discussed later. Five or more violations within a period of 2 years, or blatant disregard of the orders of the pub, such as the non-payment of fines, breaking of seals, or operating despite the existence of an order for closure, discontinuance, or cessation of operation, in which case offenders shall be punished with a fine of not less than 500,000 pesos, but not more than 3 million pesos per day for each of violation, or imprisonment of not less than 6 years but not more than 10 years, or both, at the discretion of the court. If the offender is a juridical person, the president, manager, and the pollution control officer, or the official in charge of the operation, shall suffer the penalty herein provided. So for those who are technically involved, that would be for Republic Act 9275 or the Philippine Clean Water Act of 2004. The next law that we're going to discuss is RA 8749. RA 8749, it is an act providing for a comprehensive air pollution control policy and for other purposes. Now, as we learn about hydrologic cycle, a polluted air can really affect our clean water. Therefore, it can also be contaminated if we have a polluted air. And now, a law or an act protecting our right to clean air, it is the Republic Act number 8749. So it was being approved June 23, 1999 under the presidency of President Irap Joseph Ejercito Estrada. This law, it has a 7 chapters and 56 sections. On the section 1 of this law, title of this law, this act shall be known as the Philippine Clean Air Act of 1999. Section number 2, Declaration of Principle. The state shall protect and advance the right of the people to a balanced and healthful ecology that in accord with the rhythm and harmony of nature. The state shall promote and protect the global environment to attain sustainable development while recognizing the primary responsibility of local government units to deal with environmental problems. The state recognizes that the responsibility of cleaning the habitat and environment is primary area based. The state also recognizes the principle that polluters must pay. And finally, the state recognizes that a clean and healthy environment is for the good of all and should therefore be the concern of all. Now, under Section 3 of this Republic Act, Declaration of Policies, the state shall pursue a policy of balancing development and environmental protection. To achieve this end, the framework for sustainable development shall be pursued. It shall be the policy of the state to A. Formulate a holistic national program of air pollution management that shall be implemented by the government through proper delegation and effective coordination of functions and activities. B. Encourage cooperation and self-regulation among citizens and industries through the application of market-based instruments. C. Focus primarily on pollution prevention rather than on control and provide for a comprehensive management program of air pollution. D. Promote public information and education and to encourage the participation of an informed and active public in air quality planning and monitoring. And E. Formulate and enforce a system of accountability for short and long-term adverse environment impact of a project, program, or activity. This shall include the setting up of a funding or guarantee mechanism for cleanup and environmental rehabilitation and compensation for personal damages. Now, on the Section 4 of the Article 1 of this Republic Act, recognition of rights. Pursuant to the above declared principles, the following rights of citizens are hereby sought to be recognized, and the state shall seek to guarantee their enjoyment. A. The right to breathe clean air. B. The right to utilize and enjoy all natural resources according to the principles of sustainable development. C. The right to participate in the formulation, planning, implementation, and monitoring of environmental policies and programs and the decision-making process. D. The right to participate in the decision-making process concerning development policies, plans and programs, projects, or activities that may have adverse impact on the environment and public health. E, the right to be informed of the nature and extent of the potential hazard of any activity, undertaking, or project to be served timely notice of any significant rise in the level of pollution and the accidental or deliberate release into the atmosphere of harmful hazardous substances. F. The right of access to public records, which a citizen may need to exercise his or her rights effectively under this Act. G. The right to bring action in court or quasi-judicial bodies to enjoin all activities in violation of environmental laws and regulations, to compel the rehabilitation and cleanup of affected area, and to seek the imposition of penal sanctions against violators of environmental laws. And H. The right to bring action in court for compensation of personal damages resulting from the adverse environmental and public health impact of a project or activity. For permits and clearances and getting the permits and clearances under this act is been stated in the Article 2, Sections 16, 17, and 18. Section 16, permits. Consistent with the provision of this act, the department shall have the authority to issue permits as it may determine necessary for the prevention and abatement of air pollution. Said permits shall cover emission limitations for the regulated air pollutants to help attain and maintain the ambient air quality standards. These permits shall serve as management tools for the LGUs in the development of their action plan. Section 17, emission quotas. The department may allow regional industrial center that is designated as special airshed to allocate emission quotas to pollution sources within its jurisdiction that qualify under an environmental impact assessment system programmatic compliance program pursuant to the implementing rules and regulations of Presidential Decree number 1586. Section 18, financial liability for environmental rehabilitation. As part of the environmental management plan attached to the environmental compliance certificate pursuant to Presidential Decree number 1586 and rules and regulations set therefore, the department shall require program and project proponents to put up financial guarantee mechanisms to finance the needs for emergency response, clean up rehabilitation of areas that may be damaged during the program or project's actual implementation. Liability for damages shall continue even after determination of a program or project where such damages are clearly attributable to that program or project and for a definite period to be determined by the department and incorporated into the environmental compliance certificate. Financial liability instruments may be in form of a trust fund, environmental insurance, surety bonds, letters of credit, as well as self-insurance. The choice of the guarantee instruments shall furnish the department with evidence of availment of such instruments. Nakasaad din sa batas na ito yung pagbaban or pagsusunog ng mga dried leaves. It can be imprisoned from 1 to 3 days or pwede kayong magmulta ng 300 pesos to 1,000 pesos. Chapter 6, if you're going to break this act, it has fines and penalties. It is being discussed in the chapter 6 of the RA 8749, section 45, 46, 47, and 48. Section 45, violation of standards for stationary sources. For actual exceedance of any pollution or air quality standards under this act or its rules and regulations, the department, through the PUB, Pollution Adjudication Board, shall impose a fine of not more than 100,000 pesos for every day of violation against the owner or operator of a stationary source until such time that the standards have been complied with. In Section 46, violation of standards for motor vehicles. No motor vehicle shall be registered with the DOTC unless it meets the emission standards set by the department as provided in Section 21 thereof. That's why before we register our vehicle, we need to do an emission testing. Section 47, fines and penalties for violations of other provisions in the Act. For violations of all other provisions provided in this Act and of the rules and regulations thereof, a fine of not less than 10,000 pesos but not more than 100,000 pesos or 6 months to 6 years imprisonment or both shall be imposed. If the offender is a juridical person, the president, manager, directors, trustees, the pollution control officer, or the official directly in charge of the operation shall suffer the penalty herein provided. Section 48, gross violation. In case of gross violation of this act or its implementing rules and regulations, the PUB shall recommend to the proper government agencies to file the appropriate criminal charges against the violators. The PUB shall assist the public prosecutor in the litigation of the case. Gross violation shall mean A. Three or more specific offenses within a period of 1 year. B. Three or more specific offenses with 3 consecutive years. C. Blatant disregard of the orders of the pub, such as but not limited to the breaking of seal, padlocks, and other similar devices, or operation despite the existence of an order for closure, discontinuance, or cessation of operation. And D. Irreparable or grave damage to the environment as a consequence of any violation of the provision of this act. Offenders shall be punished with imprisonment of not less than 6 years but not more than 10 years at the discretion of the court. If the offender is a juridical person, the president, manager, directors, trustees, the pollution control officer, or the officials directly in charge of the operation shall suffer the penalty herein provided. Okay, that would be for the Republic Act 8749, or also known as the Philippine Clean Air Act of 1999. The next law that we're going to discuss is the RA 9003. Now, RA 9003, it is an act providing for an ecological solid waste management program, creating the necessary institutional mechanisms and incentives, declaring certain acts unprohibited and providing penalties, appropriating funds, therefore, and for other purposes. Again, we all know that improper disposal of our solid waste can lead into harm effects to our water, since we all know that if we don't dispose our garbage properly, specifically solid waste, it will run into our waters, plastics, and any solid waste that can have harmful effect also to our marine bodies, especially to our waters, in which it will return and then it will have a negative impact to us humans in the long run. It was being approved January 26, 2001 under the presidency of President Gloria Macapagal Arroyo. It has 7 chapters and 66 sections. On the section 1 of this RA 9003, this act shall be known as the Ecological Solid Waste Management Act of 2000. Section 2, Declaration of Policies. It is hereby declared the policy of the state to adopt a systematic, comprehensive, and ecological solid waste management program which shall A. Ensure the protection of the public health and environment. B. Utilize environmentally sound methods that maximize the utilization of valuable resources and encourage resource conservation and recovery. C. Set guidelines and targets for solid waste avoidance and volume reduction through source reduction and waste minimization measures, including composting, recycling, reuse, recovery, green charcoal process, and others before collection, treatment, and disposal in appropriate and environmentally sound solid waste management facilities in accordance with ecological sustainable development principles. D. Ensure the proper segregation, collection, transport, storage, treatment, and disposal of solid waste through the formulation and adoption of the best environmental practice in ecological waste management, excluding incineration. E. Promote national research and development programs for improved solid waste management and resource conservation techniques, more effective institutional arrangement, and indigenous and improved methods of waste reduction, collection, separation, and recovery. F. Encourage greater private sector participation in solid waste management. G. Retain primary enforcement and responsibility of solid waste management with local government units while establishing a cooperative effort among the national government, other local government units, non-government organizations, and the private sector. H. Encourage cooperation and self-regulation among waste generators through the application of market-based instruments. I. Institutionalize public participation in the development and implementation of national and local integrated comprehensive and ecological waste management programs. And J, strengthen the integration of ecological solid waste management and resource conservation and recovery topics into the academic curricula of formal and non-formal education in order to promote environmental awareness and action among the citizenry. Under this law, we are being encouraged to segregate our waste, especially the solid waste, and then we do composting, recycle, and then reuse of our solid waste. What are the prohibited acts under this law? It is being discussed in the chapter 6 of this RA 9003, the penal provisions, section 48. Prohibited acts. The following acts are prohibited. 1. Littering, throwing, dumping of waste matters in public places such as roads, sidewalks, canals, esteros or parks and establishments, or causing or permitting the same. 2. Undertaking activities or operating, collecting, or transporting equipment in violation of sanitary operation and other requirements or permits set forth and established pursuant. 3. The open burnings of solid waste. 4. Causing or permitting the collection of non-segregated or unsorted wastes. 5. Squatting in open dumps and landfills. 6. Open dumping, burying of biodegradable or non-biodegradable materials in flood-prone areas. 7. Unauthorized removal of recyclable material intended for collection by authorized persons. 8. The mixing of source-separated recyclable material with other solid waste in any vehicle, box, container, or receptacle used in solid waste collection or disposal. 9. Establishment or operation of open dumps as enjoined in this Act or closure of said dumps in violation of Section 37. 10. The manufacture, distribution, or use of non-environmentally acceptable packaging materials. 11. Importation of consumer products packaged in non-environmentally acceptable materials. 12. Importation of toxic waste misrepresented as recyclable or with recyclable content. 13. Transport and dump lug in bulk of collected domestic, industrial, commercial, and institutional wastes in areas other than centers of facilities prescribed under this Act. 14. Site preparation, construction, expansion, or operation of waste management facilities without an environmental compliance certificate, ECC, required pursuant to Presidential Decree number 1586 on this act and not conforming with the land use plan of the LGU. 15. The construction of any establishment within 200 meters from open dumps or controlled dumps or sanitary landfill. And 16. The construction or operation of landfills or any waste disposal facility on any aquifer, groundwater, reservoir, or watershed area under any portions thereof. And number 16, groundwater is being stated and included. So, what are the fines and penalties if we're going to prohibit this act? It is being stated in the section 49, fines and penalties. A. Any person who violates section 48, paragraph 1, shall upon conviction be punished with a fine of not less than 300 pesos, but not more than 1,000 pesos, or render community service for not less than 1 day to not more than 15 days to an LGU where such prohibited acts are committed or both. Remember, Section 48, Paragraph 1, mayroon tayong hinahawakan na solid waste tapos itatapon na lang natin basta-basta. It is a prohibition of this act under Section 48, Paragraph 1. B. Any person who violates Section 48, paragraphs 2 and 3, shall upon conviction be punished with a fine of not less than 300 pesos, but not more than 1,000 pesos, or imprisonment of less than 1 day, but not more than 15 days, or both. C. Any person who violates Section 48, paragraphs 4, 5, 6, and 7, shall upon conviction be punished with a fine of not less than 1,000 pesos, but not more than 3,000 pesos, or imprisonment of not less than 15 day, but not more than 6 months, or both. And D. Any person who violates Section 48, paragraphs 8, 9, 10, 11, for the first time shall, upon conviction, pay a fine of 500,000 pesos plus an amount not less than 5%, but not more than 10% of his net annual income during the previous year. The additional penalty of imprisonment of a minimum period of 1 year, but not to exceed 3 years, and the discretion of the court, shall be imposed for second or subsequent violations of Section 48, paragraphs 9 and 10. E. Any person who violates Section 48, paragraphs 12 and 13, shall, upon conviction, be punished with a fine not less than 10,000 pesos, but not more than 200,000 pesos, or imprisonment of not less than 30 days, but not more than 3 years, of or both. F. If any person who violates Section 48, paragraphs 14, 15, and 16, in which the groundwater is being stated, shall, upon conviction, be punished with a fine not less than 100,000 pesos, but not more than 1 million pesos, or imprisonment not less than 1 year, but not more than 6 years, or both. That would be for this Republic Act 9003, nagsasaad na kailangan itapon natin ng maigi at in a proper way ang ating mga solid waste para hindi ito makaapekto sa atin sa darating na mga panahon. Okay, for the last Republic Act or law that will be dealing, even though it is last, for sure it will not be the least. We have Republic Act 6969. It is an act to control toxic substances and hazardous and nuclear waste, providing penalties for violations thereof and for other purposes. Now, from the word itself, it is a toxic substance and, of course, hazardous waste. So, from that words, it is the most dangerous waste of all. So, kahit konti lang or maliit lang yung waste na mapupunta sa environment, talagang napakalaki na ng effect and impact nito sa lahat ng mga living things within the affected area. So it is very dangerous that this kind of waste will go to our groundwater. That's why this law is being discussed because it is connected in protecting our groundwater. This law, it was being approved October 26, 1990. This law, it has 20 sections. Section 1 of this RA 6969, this act shall be known as the Toxic Substances and Hazardous and Nuclear Wastes Control Act of 1990. Section 2, Declaration of Policy. It is the policy of the state to regulate, restrict, or prohibit the importation, manufacture, processing, sale, distribution, use, and disposal of chemical substances and mixtures that present unreasonable risk and or injury to health or the environment, to prohibit the entry, even in transit, or hazardous and nuclear waste and their disposal into the Philippine territorial limits for whatever purpose, and to provide advancement and facilitate research and studies on toxic chemicals. So the scope of this RA 6969 stated in Section 3, this act shall cover the importation, manufacture, processing, handling, storage, transportation, sale, distribution, use, and disposal of all unregulated chemical substances and mixtures in the Philippines, including the entry, even in transit, as well as the keeping or storage and disposal of hazardous and nuclear wastes into the country for whatever purpose. So, what are the objectives of this Republic Act? In Section 4, it is being stated uh, the objectives of this act are A, to keep an inventory of chemicals that are presently being imported, manufactured, or used, indicating, among others, their existing and possible uses, test data, names of firms manufacturing or using them, and such other information as may be considered relevant to the protection of health and the environment. B, to monitor and regulate the importation, manufacture, processing, handling, storage, transportation, sale, distribution, use, and disposal of chemical substances and mixtures that present unreasonable risk or injury to health or to the environment in accordance with national policies and international commitments. C. To inform and educate the populace regarding the hazards and risks attendant to the manufacture, handling, storage, transportation, processing, distribution, use, and disposal of toxic chemicals and other substances and mixture. And D. To prevent the entry, even in transit, as well as keeping or storage and disposal of hazardous and nuclear waste into the country for whatever purpose. So, what are the prohibitions in this act? It is being stated in Section 13, prohibited acts. The following acts and omissions shall be considered unlawful. A. Knowingly use a chemical substance or mixture which is imported, manufactured, processed, or distributed in violation of this act or implementing rules and regulations or orders. B. Failure or refusal to submit reports, notices, or other information, access to records as required by this act, or permit inspection of establishment where chemicals are manufactured, processed, stored, or otherwise held. C. Failure or refusal to comply with the pre-manufacture and pre-importation requirements. And D. Cause, aid, or facilitate directly or indirectly in the storage, importation, or bringing into Philippines territory, including its maritime economic zones, even in transit, either by means of land, air, or sea transportation, or otherwise keeping in storage any amount of hazardous nuclear waste in any part of the Philippines. So, what are the fines and penalties if we're going to prohibit this act? It is being discussed in Section 14 and Section 15 of this RA 6969. Section 14, Criminal Offenses and Penalties. A1. The penalty of imprisonment of 6 months and 1 day to 6 years and 1 day, and a fine ranging from 600 pesos to 4,000 pesos shall be imposed upon any person who shall violate Section 13 A to C of this act and shall not be covered by the probation law. If the offender is a foreigner, he or she shall be deported and barred from any subsequent entry into the Philippines after serving his or her sentence. 2. In case any violation of this act is committed by a partnership, corporation, association, or any juridical person, the partner, president, director, or manager who shall consent to or shall knowingly tolerate such violation shall be directly liable and responsible for the act of the employee and shall be criminally liable as a co-principal. 3. In case the offender is a government official or employee, he or she shall, in addition to the above penalties, be deemed automatically dismissed from office and permanently disqualified from holding any elective or appointive position. B1. The penalty of imprisonment of 12 years and 1 day to 20 years shall be imposed upon any person who shall violate Section 13D of this Act. If the offender is a foreigner, he or she shall be deported and barred from any subsequent entry to the Philippines after serving his or her sentence. 2. In any case of corporations or other associations, the above penalty shall be imposed upon the managing partner, president or chief executive, in addition to an exemplary damage to at least 500,000 pesos. If it is a foreign firm, the director and all officers of such foreign firm shall be barred from entry into the Philippines, in addition to the cancellation of its license to do business in the Philippines. 3. In case of the offender is a government official or employee, he or she, in addition to the above penalties, be deemed automatically dismissed from office and permanently disqualified from holding any elective or appointive position. C. Every penalty imposed for the unlawful importation, entry, transport, manufacture, processing, sale, or distribution of chemical substances or mixtures into or within the Philippines shall carry with it the confiscation and forfeiture in favor of the government of the proceeds of the unlawful act and instruments, tools, or other improvements, including vehicles, sea vessels, and aircrafts used in or with which the offense was committed, chemical substances so confiscated and forfeited by the government at its option shall be turned over to the Department of Environmental and Natural Resources for safekeeping and proper disposal. D. The person or firm responsible or connected with the bringing or importation into the country of hazardous or nuclear wastes shall be under obligation to transport or send back said prohibited wastes. Section 15. Administrative fines. In all cases of violations of this Act, including violation of implementing rules and regulations which have been duly promulgated and published in accordance with Section 16 of this Act, the Secretary of Environment and Natural Resources is hereby authorized to impose a fine of not less than 10,000 pesos, but not more than 50,000 pesos, upon any entry or entity found guilty thereof. The administrative fines imposed and collected by the Department of Environment and Natural Resources shall accrue to a special fund to be administered by the department exclusively for projects and research activities relative to toxic substances and mixtures. So that was the last law, uh, Republic Act 6969. Thank you for listening. Hope you have learned something regarding the law protecting from water, air, solid waste, and then the hazardous waste in connection so that our groundwater can be protected since all of that law is connected and discharges somehow to our groundwater. Thank you for listening for today's discussion and have a good day, everyone.